Welcome to the Country Watch Political Intelligence Briefing Quick Hits, a weekly briefing of the hot stories across the world in brief. I'm Denise Youngblood-Coleman, the Chief Editorial Officer and Senior International Affairs Analyst at Country Watch. This week's edition is a special edition focused on recent events in the United States. On the agenda, the striking down of Roe v. Wade and the end to federal protections for abortion rights in the United States. On June 24, 2022, as presaged by the draft that was leaked in May 2022, the Supreme Court of the United States struck down Roe v. Wade. The 1973 landmark case ruled that a woman's freedom to choose to have an abortion without undue governmental restriction was protected by the Constitution of the United States. The decision had been made under the basis of the Due Process Clause of the 14th Amendment to the United States Constitution, which provides for the right to privacy and protects a woman's right to choose to have an abortion. With the ruling by the highest court of the land on June 24, 2022, those rights were no longer protected by the Constitution of the United States. The Conservative majority, made up by Chief Justice John Roberts, Associate Justice Clarence Thomas, Associate Justice Samuel Alito, Associate Justice Neil Gorsuch, Associate Justice Brett Kavanaugh, and Associate Justice Amy Coney Barrett, all ruled in favor of ending abortion rights. The Liberal minority, composed of Associate Justice Sonia Sotomayor, Associate Justice Elena Kagan, and Associate Justice, who is about to retire, Stephen Breyer, issued a searing dissent against the ruling. The majority decision asserted the following, and I quote, "The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elective representatives." Unquote. The majority ruling also pronounced that Roe v. Wade had been wrongly decided from the start, declaring that the landmark 1973 ruling was, and I quote, "egregiously wrong and on a collision course with the Constitution from the day it was decided." Unquote. The ruling on the case of Dobbs v. Jackson Women's Health Organization was 6-3, with all of the conservative justices voting against abortion rights. Technically, though, the striking down of Roe v. Wade was a 5-4 decision, with Chief Justice Roberts, in his concurring opinion, attempting to stake out the middle ground of sorts. He argued that Roe v. Wade did not need to be struck down in its entirety and drew upon the 15-week limit on abortion in Mississippi. In his concurrence, Roberts said that he agreed with the majority opinion on Dodd, but called for a more measured course, specifically noting that he would have upheld, let me repeat that again, he would have upheld the 1973 precedent ensconced in Roe v. Wade. In his opinion, Associate Justice Alito appeared unmoved by the idea that the decision would deleteriously affect the personal sovereignty of women. He instead argued that by re-empowering states with the authority to decide on the legality of abortion, the ruling allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. He added, and I quote, "Women are not without electoral or political power." Alito's opinion also took a clear shot at Chief Justice Roberts for attempting to split the difference with tighter abortion restrictions. According to Alito, Roberts' middle way would only prolong the turmoil of Roe v. Wade. Alito said that finding Mississippi's 15-week law constitutional would open the door for SCOTUS, that is the Supreme Court, to decide on the constitutionality of other states' laws with varying deadline restrictions on abortion. In their dissent, Breyer, Sotomayor, and Kagan vehemently condemned the ruling, noting that, and I quote, "it says that from the very moment of fertilization, a woman has no rights to speak of." They added, and I quote, "whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens." Unquote. Breyer, Sotomayor, and Kagan also issued the searing condemnation of the decision. They wrote that it consigned women to, and I quote, "second-class citizenship." But they also warned that it would consign women to a revanchist past. Of significance was the majority position that the appending of precedent of the juridical concept of stare decisis was rooted in the court's history. Notably, the justices in the majority referenced SCOTUS's historic decision to overrule Plessy versus Ferguson, which was rooted in racist, separate but equal underpinnings, via Brown versus the Board of Education decision. In Brown versus the Board of Education, the court ruled unanimously that racial segregation in public schools violated the 14th Amendment of the Constitution. Stare decisis allows for the overturning of decisions in cases only of exceptional circumstances, but it must be emphasized that not all exceptional circumstances were likely to be viewed in the same way. That is to say, enshrining equal rights by overruling Plessy in favor of Brown was not likely to be regarded in the same lights as stripping away constitutionally protected reproductive liberty under Roe with Dobbs. Stated differently, taking away rights was not likely to be regarded in the same way and through the same valence as bestowing rights. The deployment of the example of Plessy versus Ferguson by the Supreme Court was somewhat ironic given its separate but equal doctrine. Specifically, abortion access across the United States would now be precisely separate but equal, with low-income women in conservative states likely to endure a heavy burden as regards their reproductive decisions. The justices of the minority recognized these consequences, and in their dissent, they vociferously accused the Supreme Court of ignoring its guiding principle of stare decisis while consigning women to second-class citizenship. Indeed, they specifically warned that the burden would place an undue burden on low-income women. The minority dissent further warned that other Supreme Court precedents that had secured settled freedoms involving bodily integrity, familial relationships, and procreation were now in grave danger. While Associate Justice Alito attempted to disengage and disentangle abortion from other unenumerated rights, stating that other liberties protected under the 14th Amendment do not involve the critical moral question posed by abortion, other unenumerated rights were now nonetheless at risk of being struck down. Of particular significance, and let me repeat again there, of particular significance was Justice Thomas's opinion in which he wrote that the court should re-examine precedents on cases dealing with contraception, same-sex marriage, and same-sex sexual intercourse. A crucial question posed is as follows. If the only freedoms deserving constitutional protections had to be deeply rooted in a nation's history and traditions, what other rights could be appended? And how precisely does one measure rights and freedoms along a historical axis? Could the right to suffrage for women and people of color be deemed insufficiently rooted in the nation's history? What about marriage equality? Many freedoms and rights could well be in the crosshairs of the Supreme Court going forward. At issue would be the right to obtain contraceptives as set forth in Griswold versus Connecticut, the right to interracial marriage as set forth in Loving versus Virginia, the right to engage in private consensual sexual acts as set forth in Lawrence versus Texas, and the right to same-sex marriages as set forth in Obergefell versus Hodges. Speaking to the possibility of a broader collapse of rights to come, Breyer, Sotomayor, and Kagan warned that the ruling Dobbs versus Jackson's Women Health Organization would be used to challenge other cases involving individual freedoms. They wrote, and I quote, "Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other." The immediate effects of the ruling by the Supreme Court would be that states would respectively decide how to regulate or even prohibit abortion. With trigger laws in place in 22 states, those 22 conservative states would outlaw abortion immediately. In states without trigger laws but under Republican control, it was very likely that legislation would quickly be passed to ban abortion in those states. In states under Democratic control, it is very likely that legislation would be advanced to augment existing abortion rights, perhaps even providing further measures to assist women from across the country in search of abortions. When the leaked draft of the ruling surfaced in May 2022, there were stark warnings that the public resonance was not expected to be positive. To be precise, the striking down of Roe v. Wade and the 50-year precedent protecting abortion rights along with it was being celebrated by conservatives in the United States. They viewed it as a long-sought triumph. But for the majority of Americans who, according to survey data, did not want to see Roe v. Wade struck down, the ruling was a stunning blow, and the reaction was a mix of despair and outrage. After the ruling in June 2022, polling data from CBS News shows that 59% of Americans disapproved of the Supreme Court's decision to overturn Roe v. Wade and take away federal protections for abortion rights. On the other side of the equation, 41% of Americans approved of the ruling. The perception by the public was starkly gendered, with 67% of women disapproving of the decision and only 33% of women approving of it. Men were more closely divided, with 49% approving of the ruling and 51%, still a majority, disapproving. The partisan breakdown was unambiguous. While Republicans largely approved of the decision, Democrats and independents did not. Indeed, 78% of Republicans approved of the decision to strike down Roe v. Wade. Only 38% of independents and 17% of Democrats felt that way. Instead, 83% of Democrats and 62% of independents disapproved, with a meager 22% of Republicans feeling the same way. In the next edition, I'll be covering the House Select Committee's probe into the January 6th attack on Capitol Hill. There were multiple testimonials given regarding Trump's glee that his own supporters wanted to hang his own vice president, Mike Pence. There was testimony by Cassidy Hutchinson and she is an aide in the White House. She was an aide in the White House. That Trump lunged for a Secret Service agent when he was taken back to the White House instead of being allowed to go to the Capitol with his supporters attacking the seat of legislative power. There was testimony from Hutchinson that Trump didn't care that his supporters were armed and dangerous. In fact, he wanted weapons detectors removed to accommodate them and their weapons. Of significance will be the bombshell revelations from key witnesses from within the Trump inner circle about pardons sought for wrongdoing by several Trump supporters and Republicans, to evidence of witness tampering, which is a felony, and also further along to a pattern of seditious conspiracy emanating from inside the Oval Office with Donald Trump as the locus. I'll also cover European Commission's recommendations for the EU candidate status for both Ukraine and Moldova. I'll cover the war in Ukraine and a strike on a shopping center, as well as a separate strike on a humanitarian aid center by Russia. I'll look at Lithuania's overland shipment restrictions that will affect the Russian enclave of Kaliningrad. I'll include coverage of the upcoming election in Israel, the 5th in 3 years. Staying in the region, I'll also look at the revived JCPOA talks, that is, the Iran nuclear deal negotiations, which has received some backing from a handful of Israeli intelligence generals. Subscribers can read more about these and other stories at the Country Watch website at www.countrywatch.com. I'd also like to take this time to mention my comprehensive Afghanistan withdrawal report called Sunset in the Graveyard of Empires, which is available for purchase on Amazon.com. Thank you for your time. Have a great day, and remember, now more than ever, we live in an interconnected world.